Welcome back. A federal judge is seemingly skeptical about a lawsuit filed against the Department of Government Efficiency, also known as DOGE. 14 states are suing to restrict the department's access to sensitive data of Americans, including through the Treasury Department.
They're also suing to prevent the firing of probationary federal workers, claiming it's executive overreach. But Judge Tanya Chutkan says the states have not yet established that there is imminent harm that could be avoided by restraining the department. A ruling is expected to come by the end of the day today.
All right, here we go. We got our chief legal analyst, Khalif Rhodes, with us this morning. So, Khalif, first of all, good morning.
Good morning.
It seems like the highlighted little phrase there, imminent harm.
Yes.
All right, that's sort of the buzz phrase. What does that mean? What do states need to prove in order for there to be imminent harm?
Well, courts are reluctant to grant a temporary restraining order, period. Let's start with that part. And then, so first of all, if you have a temporary restraining order you're trying to get in this ex parte, meaning I don't give you notice, I want you to stop doing something. I'm not even going to tell you, Julian. I'm just going to go to the court and say, hey, court, grant this. Don't let Julian know I want him to stop, and then they'll grant it. Those are extremely hard. This is not the case. This is one where they've given, the states have given the federal government notice. Hey, we want you to stop doing this. We're going to have a hearing. Come to court and explain it. The courts are a little bit more inclined to grant those, but it's really hard when it's an emergency one, and that's what they're asking for here. So when it's an emergency temporary restraining order, then it's heightened. You have to not only show that there's going to be some irreparable harm. You not only have to show that, that there's this balancing act that has to happen, but it has to be imminent. That's not tomorrow. That's not next week, but it's right now. And there's really not a number on it, but I guess you'll know it when you see it. And what the standard is, it's not, beyond a reasonable doubt. That's the criminal standard. It's not a preponderance of the evidence, but it's clear and convincing. It's clear, it's firm, it's understood. When you see it, you know that standard is there. And Judge Chutkan is saying that she doesn't believe that standard has been met. She believes that DOGE is doing a number of things that is kind of sporadic, and that kind of makes it hard to be predictable for the attorneys general in the multiple states, the 14 plus that have brought this claim, to be able to point to, well, where is the imminent harm actually going to occur? Not predictable, not where can I foreshadow it being, but where do I actually seeing myself or individuals in my state being harmed?
And again, we don't have an official ruling on this, but is that the only reason why the judge would be potentially leaning this way? Or are there other reasons, too, that she pointed out?
Well, I've said this all the time. When you listen to these hearings, judges will foreshadow their decision based on the questions they ask. And so I had a judge that told me when I was clerking for him, I just want the attorneys to answer my question. I already kind of know where I want to go. I don't need you to dance around. I don't need you to tiptoe and, placate for your clients. I need you, if I ask you a question, I'm kind of, tipping and tinkering on the edge, and either you can lean me one way or lean me another way. She was asking questions specifically, well, show me where the imminent harm is. Explain to me how you can get here. While she also had a number of questions and concern for the Justice Department, for the Trump administration. Well, you can't explain how these folks are being fired. You can't explain to me how the Trump administration, specifically Elon Musk, has unfettered access and control to be able to fire, to be able to hire, to be able to slash contracts without any government congressional control. So she had questions for both sides. But if you listen to the questions she had regarding imminent harm, specifically them being able to explain where it was going to come from and who would be damaged and how fast they would be damaged, there really wasn't an answer for that, which leads me to believe that not only did she tip her hat to that she's already had her mind made up. She just didn't have an order drafted.
Khalif, it almost seems like where there's smoke, there's fire. So right now they can't prove any imminent harm. But it also seems like Judge Chutkan was saying, now once everything goes through and we see some things happen, there could be a room for something else. Is there room in the future for something to happen?
100%. It goes to the progression of what we're talking about. And so you're spot on with your question. Right now, we're talking about an urgent, something that I need immediate, this temporary restraining order. But then we can go for a permanent restraining order. We can do for something that's more permanent, that you'll have a longer hearing. You'll have a more flushed out process. You won't have something that needs to be imminent. Yes, you'll have to show irreparable harm. And I have to remind folks at home, irreparable harm is harm that money can't fix. So you're pointing to something where you can't say, you know what, there's a dollar amount that can be sent to that amount to fix it. No, when you're looking for irreparable harm, no dollar amount can fix it. So on top of that, you have imminent harm that's irreparable, that's even higher. So now if we go to a permanent injunction, we don't need the imminent. We just need you to show the irreparable harm. Lower standard, you'll be able to have more facts to support your case. But yes, further down the road, I think she did tip her hat to saying the harm may not be there now, but it may be there in the future.
Is this going to set any kind of precedent or give an example to other states or organizations nationwide that are trying to catch their breath at how quickly these executive orders and how quickly DOGE is making these cuts, and everyone's going, wait. So the claims are popping up all over the place, lawsuits. We're going to talk about this later, but What do you think? What kind of example does this set for other states who might want to file some type of lawsuit saying, "Hey, do we just need to sit back and wait for the dust to settle before we can file?"
What I'd recommend to all those folks is draft it now. If you see that there's things on the horizon that needs to be attached and they need to be attacked, I should say, on the state level where you're challenging the federal government, draft it now, wait for the claim to arise, and then file it. And I think that's what they're doing. Most of these states have already had these things drafted. They're just filing them when these rules or executive orders roll out.